there's really no reason, even if the client is a non-issue setting, you go to court, afterwards, dear Mary, dear John, it's good to see you at court. We decided to reset the case. You understand it's going to be on in 2 months. We're still trying to negotiate with the DA, and you told me that you'd be willing to take a probated sentence. Something like that in your file, which takes maybe 5 minutes or less, when the client comes back and says, I never was explained what would happen in the case. I never knew that this would have been offered. The attorney didn't tell me about this aspect of it. There's nothing better for your own protection than to come up with several emails that where you did that. Okay? The old, well, I told him and he just didn't remember, probably is not going to fly. And while I'm on it, the burden, even though if you go to trial, the burden is on the commission. Prior to that, it's really on you to prove that you didn't, if you want to get it dismissed, didn't commit professional misconduct. So that's something to keep in mind, that you're trying to convince them to dismiss the case. With a fee dispute, we've talked about some of the prophylactic aspects you can do about that. We talked about the arbitration and what you need to know if you're going to use the arbitration clause. The resources you have with the State Bar include the grievance hotline, have the advisory opinion, all those can be used. So that really is in a nutshell of the issues that I wanted to cover. And while I'm here and not eating and can stand up here, if there are some questions that you might have about the material, you can always approach it this way, that hypothetically speaking, I would like to say, or you can say, somebody down the hall told me, what do you think about that? And of course, the advice is kind of worth what you're paying for it, so take that with a grain of salt. So, with that, let me give you an example of how a dispute can arise between an attorney and a client. And the story goes like this. There was this woman who had a pet duck, and she loved this pet duck. I mean, this was one of her most, loved it more than her family. She loved this mallard. She'd raised it since the little baby duck. They had been together for however long the lifespan of the mallard was. And then it got sick. And so she took the duck to the veterinary specialist, and the duck was stopped on the table, and the woman started explaining to the vet that this duck is really sick, and it doesn't move, and you need to do something. You need to help me save my duck. And so the vet looked at the duck and pulled out his stethoscope, put it on the duck, kind of moved it a little bit, nothing happened. And he told the lady, this is a dead duck. And she just went hysterical. I mean, it was more important to her than almost life itself, this duck. And she said, you haven't run any tests, you haven't done anything to help it, it may be in a coma, maybe you get some medicine, you really need to do something. And so the doctor kind of looked at her, shook his head, and so went into the other room and brought back a huge black Labrador retriever. This retriever put its big paws on the table where the duck was and sniffed it up, sniffed it down, turned its sad retriever eyes to the doctor, shook its head, and went off. And the lady still was not satisfied. Is there not anything else? Well, the doctor went into the other room and brought back this Siamese kitty cat. And the Siamese got on the table, sniffed the duck up and down, kind of gave a cat-like look of why am I here, and left. The vet then said, your duck is dead. Went over to the computer, wrote out this long bill, handed it to her, and wrote on the bill $500. Well, the lady was hysterical about the death of the duck, and she just went bananas over having to pay $500 for the duck. And she said, you can't charge me this. This is a dead duck. And he said, well, lady, if you had just listened to me, it would have been 20. But since we have the lab report and the CAT scan, those things are going to cost more. So the point is, when there's a dispute with a client, it's really going to be up to you to take the steps that are necessary to resolve that, and that's the way the bar is going to look at it. If you have a legitimate claim and you think that doesn't mean that you have to give back funds that are legitimately yours, but every situation is unique. And so I hope that kind of summarized. These are cases that are still going through the process. It's going to be interesting to see how the Smithman case comes out and other cases come out. You're probably going to be reading about them sometime in the state law. So, with that, I'll conclude and take any questions or any other comments or any other hypotheticals you might have.
So when putting together your contract, your contract is being signed, what are things that you feel should definitely be in there? So I mean, even especially with the flat fee situation, because I know I called the bar hotline and said, okay, can I charge a flat fee? What should my contract terms encompass? And so how detailed do I need to be as far as what services they're receiving for this set amount of money?
Well, there's a couple of things here. One, we always get into the issue of a non-refundable retainer. Okay? And a non-refundable retainer technically is doable, but also is very much frowned upon by the bar. Okay? And the reason it's frowned upon is that there's a specific provision that deals with you have to show that it's not that you have given up other clients, or there's some other reason for you to do this that rises to the level of professional loss. I am going to represent you, and I'm charging a non-refundable retainer because there are these 3 family court matters that I have. I've already been paid, and I'm giving these funds back because your case is more important, and so that's the reason for the non-refundable retainer. If you have something like that, then you're in good shape. And if you don't come close to that, because usually they will throw this out in almost any situation with a fee dispute. Okay, so that is one area you don't want to go into, a non-refundable retainer. Okay, a flat fee, and that becomes what the case is about, and only you know that. It's going to be a case that's going to go to jury trial. It's going to be a case that's going to go to appeal. It's a case that it's going to be a negotiation only. You know the attorney on the other side. I'll call up Jack. Jack will talk to me. In worst case situation, I know Jack how he handles his cases, and that case will be arbitrated, or we go to a mediator. Then, to the extent you can put that into your contract in some form, and that's the reason you're charging it, and that's good. Contingency fee, everybody knows what contingency fee is. It's very, very rare for them to go after somebody for a case where the fee is an overcharge or excessive fee. That's a real hard case to make, but they may throw other things in. So again, sort of the burden is on the attorney drawing up the document to know what services to the extent you can. Okay? And as you go along, there's nothing wrong with updating the information there, saying, you understand that now we were thinking this is going to work out a plea, you want to change that, and now it's going to cost this amount of money more, let's come in and talk about it, etc. And if you can do something like that, I think you're in really much better shape with handling your contract things. The biggest issue, of course, everybody sees this, is communications and attorneys procrastinating. So any way you can address that?
All these cases seem like it's all fee disputes and each side has legitimate maybe argument. And why the severity of losing your law license or suspension of your law license?
Well, the only commonality is between the Smithman case and the Bennett case is that Smithman fought them tooth and nail because he truly believed he didn't do anything wrong. And he went to trial. They hated going to jury trial. And I think the judge decided that he was going to be punished for that. And that's the only reason I can give. Smithman never had a grievance filed against him, never had any type of professional misconduct. At the sanctions here, and this is an interesting thing, but if you get to the stage where there's been a violation, there are 12 factors that have to be considered under the sanctions procedure, and those were not even put on in Smitherman's case, there was no other witnesses called. They just said, court heard it, considered these factors, and came back with Smitherman with a 2-year suspension. So if he loses the case on appeal, then he'll have to serve 2 years suspended just because of that. As far as the Bennett case is concerned, we had a judge who had never tried a disbarment case, and basically, the best I can tell, she thought that she was there to help collect the fee, and that I did something wrong and not paid it immediately, even though I had a right to appeal. The only good thing that I can say is the good citizens of San Antonio decided to vote her out in the last election, so she's not going to be around to hurt anybody else. And also, you go to that site, the San Antonio Express News, which I lived in San Antonio for 3 years, said she was the worst judge in Bexar County. And so that's the luck of the draw. And sometimes chickens, sometimes feathers. Technically, of the sanctions here, there are 12 factors that have to be considered. Threat to the public, reputation, difficulty during the case. And in my case, not only did they not call any witnesses during the trial, they put on no witnesses, expert, fact, client. They didn't put any on witnesses during the sanctions hearing. And we put on witnesses both times. So, I think that's going to be an interesting point on appeal. Yes, sir.
What's the status of Bob Bennett's case?
It's on appeal to the 14th Court of Appeals. Briefs have been, the appellant's brief has been filed. We're waiting for the bar to file its brief, and, we'll wait and see.
Hindsight's always 20/20. I'm just wondering, from your standpoint, what do you think you maybe could have done and would have done maybe differently now?
The attorney that's handling the case for the bar is a very fine appellate attorney by the name of Randy Roach. She's out of Austin and also has an office in San Antonio and Houston. In talking to my attorney, Tom Cunningham, Roach said if Bennett had not used the word non-appealable, had not used that one word in his contract, then there wouldn't have been a case. Okay? So if I had said non-appealable, but you need to understand everything that has to do with that, and I need to explain that to you, that would have been fine. The fact that I said non-appealable pursuant